Reagan, Justice. He had to sit back down and write why was needed, the contrast. And he wrote it out, because the first time he didn't write it out well enough. So he rewrote it and wrote it out well enough, and they approved, and I had it last week. It's all about documentation. Okay? Very many PIP adjusters now are experts in this documentation. They take seminars. The insurance companies give them all kinds of seminars on this, on billing, on medical records, on all that stuff. United Automobile, I know you guys don't deal with them, goes to trial, all right, all the time, does not attack the doc, they attack the records. In front of the jury, they begin to attack the records. They begin to ask questions of the doctor. Doctor, is it important what the person does for a living? Oh yes, then why the hell didn't you ask it here and it's not in the records? This is the type of things that they do, all right? It's about records. It's about the record keeping, because that's the only real thing that we have to prove the treatment, to prove it was necessary, to prove it was related, is the records. Okay? That's the only real thing they have and we have to give them. So when we do it well, document the case well, they can't get around it. And when you're a little sloppy, they'll catch you on the sloppiness. I swear they will, because they're looking for it. They are looking carefully for it. Very carefully. And in that light, let's be clear of what is happening. They had the legislative effort that, for all intents and purposes, is done. It's not over. It's 2 weeks of the session, but it'll be very hard for them to get something done now. Second, they're attacking you guys with declaratory actions and counterclaims. This is now the new trend. The trend is not only to not pay this PIP claim in particular, or that PIP claim in particular. The trend is to put you through the fire. State Farm, Allstate, they have all kinds of money. They can play. So they're going to use that 800-pound gorilla in the room weight against you. And they are. The deck actions. These are done. God, sorry, but I was probably one of the initiators of this. When my first year out of law school, I worked for a company that was defending insurance company, Fortune, and me and the head lawyer, Carlos Litsky, decided, wait a minute, why do we have to defend ourselves on a PIP suit when the insurance company said there's a material misrepresentation, okay, as an example, and we denied coverage? We're going to get sued. Why don't we sue first? And what we're going to sue is not for money, though we're going to look to the insured in the clinic to pay my fees. Let's see if I can do that, maybe. But the suit is to have the court declare, you're right, no coverage. That's why it's called a declaratory action. It's not an action for damages. It's not an action for money. It's an action looking to the court to declare, make a declaration. And this issue of a material misrepresentation is to make a declaration that yes, there was a material misrepresentation, therefore the insurance company doesn't have to pay. Okay. I don't know if any of you had one yet. You have. Okay. There is a little big problem. Notice how I said little big problem. Because probably you already brought it to Joe, brought it to me, all right, and it's taken care of for you. But it's the insured that's defaulting. Think about it. The insured gets sued. You guys get sued too because of the assignment. Okay? The insured defaults. The court declares no coverage by default. you lose.
What if the material misrepresentation is the fact that when the application for the auto insurance was filled out, someone who did not speak good English was with an agent from a insurance agency, and they did not ask the correct question: how many drivers are there in the family, or who is eligible to have a license, and that kind of stuff. So they're putting down just themselves, when in fact there may be two other people and so now you've got a problem because of language barrier. So now you're getting a default from the insurance company because of the fact that the application was not filled out properly, therefore it's produced material misrepresentation.
Yeah. What you said. The problem here is, yeah. And let me tell you, material misrepresentation. I'm going to give you another example. Early on in my career as a lawyer, I had State Farm. And I was having a war with State Farm. I always have a war with State Farm, but anyway. And I decided, why the hell should I have State Farm? Why am I giving them? I know it's not a great amount of money in my premium, but why should I do that? On principle, I dropped State Farm. So I went to one of these insurance agents on the street who was a friend of the owner of the law firm I was working at. And so his agent, who I knew, I went in and says, I want to insure my car. At that time, I had gotten a divorce and I was living with my parents. So I put them on the application. He said, no, don't put them. He says, why? He says, because it's going to cost you more. And they have their own car and they have their own insurance. And I said, yeah, but that's not what the question asked for. The question asked, name every person that lives with you over 14 years of age. It didn't ask if they were licensed. It didn't ask if they had their own insurance. It didn't ask if they had their own car. It asked for anybody that lived in your house over 14 years of age.
And you understand English very well.
Right. Well, but the agent fought me. And I stood up and I said, listen, if you're not going to put them down, I'm not going to buy insurance from you. I know the law. If I don't put them down, it's a material misrepresentation. No, it's not, because they got to. No, you're wrong. So it's not only even done on purpose. Sometimes it's just that people don't know. Okay?
Is that hard to prove?
How many agents will stand in a courtroom and say, yeah, I told them not to put it down?
Every single one of them.
Yeah. Okay? So this is the problem. The problem we have to fight is it a misrepresentation for real? It can only happen on the date of policy. So if I live alone, right, and my 21-year-old daughter moves in, yesterday I bought the policy. And when I got home from the agent, there's my daughter with her suitcase saying, I'm moving in that. No material misrepresentation. Because when I signed that policy, she didn't live with me. It can only happen at the moment that I sign. It cannot happen at any other time. And I do not have an obligation to update the insurance company. Florida law does not provide anything where I have to, oh, listen, I now have my daughter with me. None. No requirement.
They'll corroborate that with the driver's license. They'll check, if that person, they require their addresses as well. So they have a way.
I'll tell you some that are material misrepresentations. I'm a son, my parents. I really don't live with them because I'm living with my girlfriend. But you know what? It's my mailing address, my license address. Okay? Now I have to fight and say they weren't really living there. And that's easier to prove because I got the girlfriend to testify, and friends and stuff like that no, I did not live in that household. But still, that's how they say material misrepresentation. And they bring this deck actions. And material misrep is not the only reason. Now they bring it for not going to the EUO. The EUO ones are very specific. They have a problem. They're crazy with the Supreme Court's decision on the EUO. They're nuts about it. This has been, aside from yesterday, that has been one of the worst things that happened to insurance companies. Since The case that the Supreme Court said this in was not an EUO case. It was an IME case. What they're trying to do is get an EUO case to the appellate courts. So they filed this deck actions in circuit court so that the appeal is in the DCAs. They're trying any which way to get in front of the Supreme Court an EUO case to see if they'll change their minds. So that's one of the things that they're doing, okay, on these EUO cases. We're going to win, but they're going to appeal it because that's what they want. They want to appeal it to get this case in front of the court. And one of the reasons is, in law, maybe you will understand, there is a holding in a case where the court says this is the law, this is what's right, and there is dicta, a comment. They made a comment, all right? That really doesn't apply to the case, and we call that dicta. It's not law. So they're saying that what they said about the EUO is dicta, all right? And it's not law, so they want a case to go up there. Well, when the Supreme Court says that the EUO is inapplicable, yeah, it may be dicta, but pretty powerful dicta. Pretty powerful because they told you what their opinion is already. And there isn't a case, have you met any judge that has bought the dicta argument yet? None. There's no judge at the trial level that's buying that argument. The Supreme Court said it's not applicable. It's not applicable. I don't care if it was dicta. I don't care if that was not the issue in the case. I don't care, the judges said it. They said it was inapplicable, all right? So, this is why they're doing this on the EUOs. Again, what we have to do with that, what's happening is this insured, we need to get after him. Now, they've been doing this, and you're still treating or just finished treating the patient. So you still have some control, all right? And the control is to come running, sign a retainer with me so I can defend him. That's the control. So now I can defend him, and now they can't get the default. Because all of these I've seen, because I have the patients, you've given me the files, but they're very, very, very recent. In fact, some of them we have to wait until the demand letter passes. The time, that's how recent it is. We need to get back at those insureds. They come on, sign with my attorney so we can defend this. You're not going to have to pay me, but I want to be able to defend you, but I need to have the authority, because the first thing they're going to say when I make a notice of appearance for the insured is, was that retainer that he hired? Very important. So we don't have this problem. Now, it's already happened to another lawyer, and we've been discussing the resolution of what do we do? And how do we argue this? Because it's brand new. It's kind of like not easy. Well, one of the arguments is that the insured gave up his rights, so it doesn't matter. But I don't want to play that. I don't want to try to convince the court that it doesn't matter, because of the assignment, he didn't have the right to sue. He didn't have the right to anything, to the benefits. So it was only you that it matters to. But they're saying, no, because he didn't go to the EUO, therefore this was a condition proceeding. And so it gets very technical, and it's very, very technical. I don't want to play the technical game. I don't like playing that game. I'd rather have the insured